Welcome to this new video on international arbitration. Building on our discussion of investor-state arbitration in the previous videos, I will illustrate here how this type of arbitration relates to the public interest, and as a consequence, how investment arbitration has since several years moved to ensuring a certain form of transparency in and of the arbitral procedure and public access to hearings. Because originally investment arbitration followed a procedure based on the procedures used in regular international commercial arbitration, such proceedings were typically confidential and secret. For instance, the hearings were not public and the awards were not made public. Based on our previous discussion of investment arbitration, you may have noticed that investor-state arbitration has an important and direct impact on the daily life of the citizens of host states. Claims brought by foreign investors very often relate to acts taken by the state acting as a sovereign and based on the powers it has under the legal and constitutional arrangements of the state. Such acts, moreover, sometimes concern the protection of the environment and human rights. Investment disputes, therefore, are of interest to the general public, you and me. The increased criticism on investment arbitration, coupled with the important public interest nature of the investment disputes, has prompted changes in both the ICSID and UNCITRAL rules of arbitration. Indeed, the engagement of investment tribunals in assessing the state's exercise of their sovereign prerogatives inevitably causes tensions between the originally closed character of the proceedings and the public international law character of the disputes. Already in 2006, the ICSID arbitration rules were modified to reflect a more transparent procedure. This was followed by the adoption of the UNCITRAL rules on transparency in treaty-based investor-state arbitration in 2014. The latter have been incorporated in a convention in 2016 called the Mauritius Convention. The UNCITRAL arbitration rules only apply to treaties signed after 2014, unless, of course, both states have accepted these new rules or have signed the Mauritius Convention. You will have noted from the title of the UNCITRAL rules that these apply only to treaty-based investment arbitrations. The ICSID arbitration rules in turn apply to all ICSID arbitrations, whether they are based on a treaty, a contract, or national legislation. I should also add that investment treaties themselves can provide for rules on transparency. This has long been the case, for instance, in investment treaties of the United States and Canada, and has recently also been included in the text of the Comprehensive Economic and Trade Agreement, CETA, signed between the European Union and Canada. So what do these new rules provide? I invite you to have a look at Articles 32, 37 and 48 of the ICSID arbitration rules, and to the mentioned UNCITRAL rules on transparency. The first issue concerns the publication of information related to the case and of the award. ICSID publishes on its website when a request for arbitration has been lodged and who the parties are. The award also will be published unless one of the parties opposes it. Under the UNCITRAL rules, information on the case and the award are made public generally, unless these contain confidential or protected information. A second issue relates to amicus curiae briefs, that is, briefs submitted by friends of the court. Such briefs have as main objective to help the tribunal by bringing a perspective different from the ones presented by the parties. Most often these briefs are submitted by NGOs. This may be helpful notably in cases involving environmental or human rights issues. The ICSID and UNCITRAL arbitration rules formally allow tribunals to accept such briefs under certain specific conditions. A final element relates to the hearings. While commercial arbitrations typically hold closed hearings, the ICSID arbitration rules provide since 2006 that the tribunal may allow public access to the hearings unless one of the parties objects. In practice, public hearings do not occur in the majority of the cases because a party precisely objects to this. If it is public, the hearings are streamed live on the website of ICSID. The UNCITRAL rules in turn have as general principle that the hearings are public, but part of the hearings can be held private if there is a need to protect confidential information. With this video, we conclude our module on investment arbitration. You have learned the general principles of investment arbitration, the specificities of arbitration under the ICSID Convention, and today, the specific rules relating to transparency and public access in investment arbitrations.